Jack Smith's opening immunity brief. That's what we're going to talk about today. Welcome to Law and Society. Please subscribe and let's begin. So, there are a couple of instances upon reading the superseding indictment that I felt, and I pointed it out in the video about this, where I summarized the superseding indictment, that Donald Trump may raise those as being conduct that is within the outer perimeters of a president, and therefore want to have those immunized. And one of those instances is something that we have seen Donald Trump's attorneys talk about and write in briefs to the court about, and that is Mike Pence's conversations with Donald Trump regarding electoral votes and vote certification. Now, so the two instances, and the second instance where in the superseding indictment, where Jack Smith uh, brings up a topic that would be otherwise immune, is Mark Meadows participating in some of the uh, conspiratorial conduct with Donald Trump in regards to the electoral college votes and the fake elector scheme. So, how will these two go? We will know Jack Smith is scheduled to submit his opening brief. Judge Chutkan has ruled that it is all right for Jack Smith to submit 100 and some 120 or so pages brief that will be submitted by 5 p.m. Eastern Time on Thursday today, and uh, I've read that there will be a redacted version of it that will be available to the public. Now, I don't know if that will be available to us right when Jack Smith submits the brief and the sealed brief in court, because Judge Chutkan has to sign off on whether the redacted opening brief can be uh, made available to the public or not. And the reason for that is the preservation of evidence for the trial, so as to not materially influence uh, any witnesses or juries, uh, the jury pool, so to speak, before the trial, before a jury is picked, and therefore effectively rendering the trial uh, into a mistrial before it even begins. So there has to be parts that will be redacted that will keep us, uh, you know, well, we won't know for sure, but we may learn through reference who these are about. I, while looking at the superseding indictment, came up with the two instances that I just said. One, the communications with Vice President Pence about the Electoral College votes and the certification of those votes, and Mark Meadows about, with him being part of Donald Trump's conspiracy of the fake elector plan throughout the battleground states, including Arizona. So, why do I think these two instances will fail? Well, here's why. In both those instances, Donald Trump communicated with somebody, one of them being part of his staff, and the other one being the president of the Senate, his vice president, about election procedures, which with Mark Meadows being the fake elector plan, and the electoral college votes and the vote certification process with the president of the Senate, Mike Pence, Vice President Mike Pence. Now, in both those scenarios, the context and form and content of that conversation pertains to the certification of the votes, the electoral votes from coming from the states, and how those states are sending their electors with the fake elector scheme. None of the activities mentioned in that I just mentioned about election and electioneering is part of the president's constitutional duties. What far be it for it to be one of the president's core constitutional duties, it is not even in the outer perimeters of the president's authority because it deals with election matters that the Constitution has explicitly vested to Congress and to the various states. And that's why, because it is expressly vested out of the president's hands, it is not within the president's and in this case, in Donald Trump's authority at that time to talk to Mike Pence about the electoral votes and the certification, and it doesn't immunize the conversations and dealings with Mark Meadows about the fake elector plan. Because why? Because the context in which they are being used, the content of those materials, is about election procedures. And the president has no authority in those areas. Well, it could be so where does the immunity, as Donald's attorneys will be arguing, comes from? Because they have tried many times to bend uh, Trump v. United States, which favors Donald Trump, by implying that the communication with Mike Pence and Donald Trump are immune because the Supreme Court itself has said that it may be presumptively immune. Well, the whole point of the Supreme Court saying that it may be presumptively immune and we remand to the district court for an evidentiary hearing to find out whether they are immune or not, says that they are not absolutely immune. And the government gets to rebut the presumption that communications with the president and the vice president between them is not immune. Why? Because when Donald Trump and Vice President Pence were communicating about they were communicating about the certification of votes in the joint session of Congress, where Vice President Pence, the president of the Senate, has the ministerial function of counting the votes and then declaring the winner. There's specifically and explicitly nothing about the vice president having the power to change or to manipulate or to unduly delay the process of the certification. And that was informed to Donald Trump several times by Mike Pence and Mike Pence's aides. And that is not immune because here Donald Trump isn't talking to Mike Pence in Mike Pence's capacity as vice president of the United States. He's talking to Mike Pence in Mike Pence's capacity of president of the Senate, presiding over a constitutional function of certifying electoral votes. So the immunity doesn't work, and also the speech or debate clause protection that would immunize Mike Pence from testifying or stop him from testifying doesn't work because he was operating as president of the Senate when dealing with certification of the electoral votes. And with Mark Meadows, it is a closer call because Mark Meadows was the chief of staff of Donald Trump during his last days of his presidency. Donald Trump went through more than one chief of staff, as you will remember. And Mark Meadows was privy to conversations and to threatening calls to the election officials and politicians, in Republican politicians like the Speaker of the House um, in Arizona about the fake electors, or sending the fake electors, or changing the outcome of the votes. Well, in in Mark Meadows' capacity as chief of staff, he wasn't operating as Donald Trump's chief of staff, as Donald Trump was operating as the president of the United States. Here, Donald Trump was operating as a candidate, as an office seeker, and somebody who was going into uh, sort of meddling with and interfering with how state handles federal elections and elections of the president, over which Congress has explicitly given power to Congress. I'm sorry, the Constitution has explicitly given powers to Congress and to the various states. Mark Meadows is not working as the chief of staff to the president, but rather a co-conspirator, or a witness in this case, depending on which way Mark Meadows chooses to go. If he cooperates, he'll be a witness. If he doesn't cooperate, he'll be a co-conspirator with an office seeker, a campaigner, a candidate for president. Although he was an incumbent, that's not what his role was. Donald Trump and his lawyer's position essentially is that because he was president at the time when he had these communications are therefore immune. But the Supreme Court in Trump versus United States specifically said that just because you're president doesn't mean everything you do is immune. So the question comes to looking at each function and each conduct and seeing whether they fall into the constitutionally protected zones that Trump versus United States have created of absolute immunity or presumptive immunity. And in this case, the presumptive immunity that goes with Mike Pence and with Mark Meadows. And in neither case do they work, because the presumptive immunity is rebutted both by the fact that Mike Pence was operating as the president of the Senate, and Donald Trump had no authority constitutionally to meddle with elections, electoral votes, or certification of the votes because of the Constitution. And Mark Meadows wasn't operating as chief of staff to the president, but rather an aide or a co-conspirator to a candidate and an office seeker who was seeking to interfere in state elections and in the certification process and in the counting of the electoral votes. So this is what I expect to be the bulk of Jack Smith's argument, that the areas where that Donald Trump would bring up as areas where immunity would prevail won't apply to these two instances, and these are the reasons for which they won't. So if you have any questions about this, because you may have been a little confused because I talked about two different issues, leave those comments in the comment box, and please remember to share, subscribe, and like. That's what helps me out, and that's what keeps me going. So I really appreciate it. Thank you so much. Take care.